Following today, the high-powered tech executive from China, who's now in Canadian custody, who the U.S. wants to extradite. We want to reconnect now with our guest from earlier. Seth Weinstein is a partner with the firm Greenspan, Humphrey and Weinstein, and specializes in extradition law. And he joins me now from Windsor, Ontario. So I was asking you about Canada arresting this suspect, Seth, at the request of American authorities. So in these extradition cases, is this automatic? Would Canadian officials have any other option?
Well, so the option would be once the American authorities provide their request for extradition to the Canadian authorities, we have a group at the International Assistance Group who reviews the request, and so long as it meets the terms of the treaty and of the Extradition Act, then they would have to then go apply to a judge at the Superior Court in the province in which the extradition, the person sought, is located, and seek a warrant for that person's arrest. And so there is discretion to review the request, but if it is in compliance with the Act and the treaty, then they have to then take the next step of seeking the arrest warrant for the person.
Some have said that this is unusual, that to arrest a high-ranking executive is at the very least unusual, that these kind of arrests do take place, but maybe for more serious, hardened criminals.
Well, I mean, I would disagree with that. I mean, the extradition arrests are made all the time, sometimes for hardened criminals and sometimes for executives charged with white-collar offenses. Mm-hmm. So I don't think it's unusual with respect to the fact that it's an executive whose arrest was made. The issue, I think, will be, is she being sought for political reasons, or is there evidence of a criminal offense that's been committed? And that would be the bigger question to ask. But I don't think it's unusual simply that it's an executive who is arrested.
Now, MENG sought and was granted a publication ban. Are publication bans almost automatic in cases such as this?
No, in fact, publication bans in extradition proceedings are the exception and not the norm. Unlike in domestic proceedings where at a bail hearing a judge is obliged or a justice of the peace is obliged to issue a publication ban at a bail hearing, the opposite is true in extradition proceedings where the onus is on the person sought. So in this case, she has the obligation and the onus to prove or to establish that a publication ban is necessary to ensure her fair trial rights in the United States, not in Canada, because there's no trial in Canada. So it's a high onus for that person to meet, and so that's why publication bans in extradition bails are the exception.
So in the Huawei case, MENG was taken into custody Saturday. A bail hearing is tomorrow. Do extradition cases typically move along like this?
Yeah, that's not unusual. I mean, sometimes, the person sought has to be brought to court within 24 hours, but it's not infrequent that a bail hearing isn't heard right away. A week later is not unusual. So I don't think you can read much into that. Extradition proceedings they're supposed to be an expedited process, but they still take some time to play out.
So if the subject of an extradition request receives bail, what is their status typically? Are there financial or personal conditions?
Yes, I mean, it's no different than if you're charged domestically. You're released on generally a recognizance of bail where there would be often what are called sureties, people to supervise the individual in the community, and that person would be subject to conditions, sometimes restrictive conditions that would include likely depositing their passports to ensure that they can't travel. Perhaps there could be other conditions such as house arrest, but the bail orders are similar to those that are done domestically, and the person is treated in a similar vein in that they're treated as if they were charged domestically for the purposes of bail.
So in cases like this, Seth, even if she is granted bail, the normal procedure would be that MENG will be extradited to the U.S., right?
Well, there's then a process. I mean, just because she's sought for extradition doesn't necessarily mean that she will be extradited. There's two steps to the process. There's a judicial phase where the requesting state, in this case the United States, would have to, through the Crown Attorney in Canada, present evidence to establish that an offence has been committed in the United States. And it's a low threshold that there has to simply be some evidence of that. And then at that point, a judge would be required to commit the person for extradition. But then there's a second step, there's a ministerial step where submissions could be made and are made to the Minister of Justice if she so wishes, to try to seek to have the minister deny surrender and refuse to surrender, and circumstances such as, if this is a political offense rather than a criminal offense, those would be submissions made to the minister, who then has the discretion to still refuse extradition if there's a basis to do so.
And in that case, would she be allowed to leave Canada?
If the minister refuses to extradite, that would end the extradition proceedings. Now that's a long way away. I mean, that's the second phase of this. So the first phase would be judicial, and then the ministerial phase comes after that. But hypothetically, if the minister refused to extradite, then she would be free to leave Canada. She wouldn't be able to go to the United States, because they would then immediately arrest her, but she would be permitted, if that were to happen, to leave Canada.
Seth, appreciate you taking the time. Thank you very much.
Pleasure. Thank you.
Lawyer Seth Weinstein co-authored a textbook on extradition law.